I'm Drew Stevenson, and this is a lecture about the case Silvers versus Sony Pictures Entertainment, a Ninth Circuit decision from 2005 that applies and discusses the Expressio Unius Canon, what we call and this is for my statutory interpretation and regulation class, although this is also a sort of famous copyright case. Quick word, this is the only case I'm covering in my class about this particular canon, Expressio Unius, which basically means that if the legislature says something specifically, that that's exclusive, that the statute covers that exclusively, and we can assume that the legislature didn't omit things. In other words, if we're express and specific about something, or especially when we list some specific things, if we don't include a catch-all that says or anything else, then we're going to assume it's an exclusive list. And so the Latin phrase for this means the expression of one thing means not other things, or the exclusion of some other things. So let's look at what happened in this case, which is about a couple movies I've never watched. So this is a copyright infringement suit, and I'm only going to tell you what you really need to know for this case about copyright law. And it's brought by a pretty prominent screenwriter named Nancy Silvers against Sony Pictures. Now, and this is a picture of Nancy Silvers, her LinkedIn profile. Now, Silvers mostly writes made-for-TV movies for things like the Hallmark Channel or Lifetime Channel and so forth. And so if you like those types of movies, Nancy Silvers is your type of writer. And so this case is really about a screenplay that she wrote for a TV movie that is very similar to a movie that someone else produces a few years later. And by the way, this is the movie that she wrote, The Other Woman. So Silvers wrote a screenplay for a 1995 made-for-TV movie called The Other Woman. It's about a divorced mother who can't stand her ex-husband's new wife. But she's then diagnosed with cancer and realizes that her kids are going to she's going to leave some kids behind, and that the husband's new wife is going to be basically the stepmom for her children. So she has to accept and befriend this other woman who will raise her children. And by the way, just as a quick note, imdb.com lists at least a dozen other movies called The Other Woman. It's like there's one every other year, and dozens of TV show episodes. And most of them are not about this. And so I just felt I had to clarify which The Other Woman we're talking about. And here's a couple other things from if you really wanted to buy it on DVD, what the cover looks like. Okay, now we get to the other movie. So 3 years later, Sony releases a movie called Stepmom, in which a divorced woman is diagnosed with cancer and as a result develops a new and better relationship with her ex-husband's new wife, who's going to have to raise her children. The plot lines have obvious similarities. If you're familiar with these two actresses, this was a all-star cast. That's Julia Roberts and Susan Sarandon, who were a really big deal, at least in the 1990s. And so that kind of raises the stakes for what's going on here. That Silvers remember, she had written something under contract and wasn't even getting royalties probably from The Other Woman movie, because she just wrote it was hired to write a movie for a production company, and she wrote it, and that was the end. And then 3 years later, there's a movie that with some really famous people in it that's kind of a big movie, and she thinks it's her script that they just cleaned up a little bit. So Silvers sued Sony Pictures for copyright infringement. But here's the problem. Silvers doesn't actually technically own the copyright because she wrote it as a contract writer for a production company called Bob and Frank Films, and which also was a big deal back then. And so they actually were still the copyright owners at the time of this case. And Frank and Bob Films, Frank and Bob Films had assigned her the right to sue for copyright infringement in this case, but they retained full ownership of the copyright. This is a little weird, and I'm not sure what the lawyers were thinking, but maybe they were used to doing other areas of law and where you can assign, for example, a tort claim or other types of rights to sue to other parties. And maybe they were thinking that copyright is a type of property, and so they were thinking of like bundles of rights, and that they could keep the ownership right but give the right to sue to someone else. The problem is that the Copyright Act doesn't let you do that. And so this is a nice idea to talk about in terms of assigning rights. We do that in other areas of law, but the question is, can we do that under an area of law that's so governed by statute, like copyright? And so Silvers is not the actual owner of the copyright, and so the question is whether she can sue under the Copyright Act, and that depends on a specific section, 501B of the Act, which says that the legal or beneficial owner of a copyright may sue for infringement. And it lists a few people that count as legal or beneficial owners pretty specifically, but it actually doesn't include someone who's just been assigned the right to sue, but without an ownership stake. Now, if they'd given her even a partial ownership stake in the copyright, this might be a different case. But they didn't. They are full owners of the copyright, and she only was assigned a right to sue as part of her contract. And so only someone has an ownership interest can bring in action for copyright infringement. This means that, by the way, as an aside, I'm not a copyright law expert, but this case suggests that copyright rights to copyright or rights to royalties are not necessarily assignable in the same way that other things are, unless you're going to transfer at least some of the ownership interest with it. So the court here applies this canon, Expressio Unius. I have a picture here of the entry from Black's Law Dictionary, and says if the statute specifies who has a right to sue, basically the legal or beneficial owner, it therefore intentionally excluded the possibility of assignees of claims bringing copyright actions. In other words, because it kind of listed some situations that would count as a legal or beneficial owner, that was intended to be an exclusive list, and therefore Silvers cannot prevail in her case. That's all we're going to say about the facts and holding of the case. A quick word about the dissent. The dissent argues that the legislative history of the Copyright Act really suggests that Congress wanted to broaden the act to protect the creators of content and make it easier for them to enforce their copyrights and get royalties. So they're basically drawing an inference from that copyright assignees should have a right to sue for infringement, because that sort of enhances the value of a copyright if you can assign it to someone else as part of a contract or transaction. The dissent does not think that the Expressio Unius Canon should apply here. It also notes that there's another traditional canon that would seem to cancel it out, the principle that if something appears in case law, this is a canon that says statutory language may comprehend many different cases, even though only some are expressly mentioned by way of example. In other words, there's a sort of counter canon to Expressio Unius that says that statutes can apply to other similar circumstances besides ones that are specifically mentioned. So here's the canon and what you really need to know or remember about it. And I think that this is actually a useful concept when you're in practice to think about your case and think about the statute. And by the way, this is sometimes invoked, this canon, not only for interpreting statutes, but contracts and wills and other types of legal documents that when the more we go about mentioning single things specifically, that this excludes things that are not mentioned or omitted. And so specifically delineating something, and especially if it's a list of things, means other things were deliberately left out. That's the idea of expressio unius. And you don't have to call it that. You don't have to remember the Latin phrase. Just remember that there's this kind of rule that if we mention some specifics, that it's supposed to be an exclusive list unless it says it's a non-exclusive list. So a list of specific items or requirements or um, people that a statute applies to, or exceptions in a statute, is an exclusive list unless otherwise specified as non-exclusive. How would we do that? Think about that other canon we have about the catch-all phrases or any other such and such or blank. Well, that would kind of preempt expressio unius, because we know it actually, the Congress has put right in there that it applies to other things that are sort of similar or of the same, that share the same trait. But if we don't include that catch-all, then we're going to assume that the specific items mentioned are everything that Congress intended. And that concludes our lecture about Silvers versus Sony Pictures Entertainment.